morning or good afternoon, depending on when you're joining us. You're joining me, Helen Pugh, and my colleague Dan Clarke. We're going to be talking about the impact of Brexit on jurisdiction in contract claims. So what are we not talking about today? Well, we're not talking about Rome 1 or Rome 2. They are the applicable law provisions which used to govern applicable law in the EU context and is now part of our retained law. We're not talking about enforcement of judgments or service on EU member states, and we're not talking about arbitration, although it's right to say that not much has changed in the context of arbitration. We are still a member of the New York Convention, as are the EU member states. The main difference with Brexit in that context, and indeed the contract context as well, is that we now have the ability to issue anti-suit injunctions against EU member states again. Although whether that's going to be more theoretical than a practical tool, we've yet to see. So Dan, why are we talking about Brexit?
Well, I think the first thing is to talk about what are the key dates. Brexit itself happened, in fact, quite a long time ago on the 31st of January 2020. But there was then a transition period during which the UK was still bound by the EU rules, including those on jurisdiction and civil and commercial matters. And that period came to an end on the 31st of December 2020. So that's the key date. Sometimes referred to as IP completion date in the legislation, which is a peculiarly ugly, or implementation completion date, it's a peculiarly ugly title. I call it the end of the transition period, but whatever you call it, that's the key date, 31st of December 2020. So what's the headline? What changed on the 1st of January this year? Well, the really key point is that in effect, as far as civil and commercial jurisdiction is concerned, there was a no deal as between the UK and the EU. And that means that the UK fell out of the Brussels 1A regime and effectively became a third country. So what does that mean for us practically? It means that what are usually referred to as the common law rules now apply to jurisdiction in civil and commercial cases, including contract cases. Slightly misnamed because it's not just a matter of common law. There's quite a lot of statute in there as well. But in any event, it's the domestic rules which now apply. So those are the ones we'll be talking about mainly. But do the Brussels 1 rules still have any relevance, Helen?
Well, they do for a while, Dan. There are transitional provisions which apply as a result of the withdrawal agreement. And in practice, this is going to arise in two types of cases. Firstly, where the claim has been issued in the UK prior to the end of the transitional period. You might remember there was a debate, Dan, last year about whether you had to serve it before the end of the transitional period as well, in order to get the benefit of those transitional provisions and the continued application of Brussels 1A. And we now know, to much relief, I think, from a lot of people, that it's enough to simply issue the claim. You don't have to have served it by the end of the transition period. And the second type of case where Brussels 1A will still apply are those cases where proceedings have been issued in an EU member state and there are then connected proceedings issued here after 1st of January 2021. They will still be governed by the terms of Brussels 1A.
So what have we left behind?
Well, Brussels 1A was a rules-based system. That's probably a big headline change. So there was none of this discretionary proper place or scope for the English courts to decline jurisdiction if one of the tests in Brussels 1A was met. And those tests were broadly, if you're a defendant domiciled in a member state, then that gave jurisdiction to that member state. And then in contract matters, the key provisions were default jurisdiction depended on the place of performance of the obligation. So, for example, if you're in a service contract, then it would usually be not the place of payment, but rather the place where the service is being provided. And the only other article which was particularly important in Brussels 1A was the connected claim article, which is the anchor defendant provision, whereby you could drag a defendant into a particular jurisdiction, provided you were suing another defendant in that jurisdiction, and it was a claim which was so closely connected to the first one.
So the obvious question is, what rules are we left with now that we've left the Brussels regime? And the answer to that is the old common law rules. In other words, one has to show a good arguable case that one passes through one of the jurisdictional gateways, the claim has a reasonable prospect of success, and that England is the forum conveniens. Now, slightly later on, Helen will be talking about some of the exceptions to that regime. In simple terms, one can bypass the permission stage if there's a choice of jurisdiction clause in favour of England. But that aside, that's the very well known and very well established regime that we're now working to. In terms of what is a good arguable case, this is one of those issues that's been very heavily litigated over the years. Probably the answer is that the governing test, as it stands, is that set out by Lord Sumption in Brownlee No. 1. In other words, the claimant must supply a plausible evidential basis for the application of the gateway. If there's an issue of fact, some other reason for doubting the gateway applies, the court must take a view on the material available if it can reliably do so. That, strictly speaking, that was obiter, but I think it's probably fair to say that that's been taken to be the governing test and now applied in many cases since. So that's the sort of overview of how the common law regime works. What are the most common grounds for jurisdiction in contract claims, Helen?
Well, there's three main types, I'd say. Firstly, you've got the straightforward physical presence in the jurisdiction. Secondly, you have a category of cases where you don't need permission of the court to serve out of the jurisdiction. I'll go into those in a bit more detail shortly because they have been amended as a result of Brexit. And then you have another category of cases, which you alluded to, which are the gateways, where you do need to have permission of the court to serve out of the jurisdiction. But very quickly, maybe can you recap, Dan, on physical presence and how that works?
Yes, I mean, that's very straightforward. The defendant could be served if they're within the jurisdiction, even if they're there for a very short time. I mean, for example, if one Russian oligarch were to spot another Russian oligarch down the shops or perhaps in a department store, and they were then to serve them personally with a claim form, that would count for these purposes, however short time they were in England for. So it's pretty straightforward.
True story, that, Dan. As well as physical presence, then, we have the provisions in Rule 6.33, which have been reformed as a result of Brexit, where you can serve out of the jurisdiction without the court's permission. And there's essentially three types of cases which are covered by Rule 6.33. And firstly, you've got your employment cases, where the employee habitually carries out work in England and Wales, or that's where the business is situated in which the employee is or was engaged. Secondly, you've got your consumer contract cases, if the consumer is domiciled in England and Wales, even if the other party to that contract is not. And thirdly, and most importantly for a lot of commercial clients, are the jurisdiction clause cases, of which there are two different provisions dealing with these. Firstly, you've got your Hague Convention cases. If you have a jurisdiction clause falling within the Hague Convention, which is going to be the case most of the time with exclusive jurisdiction clauses, then you can serve out of the jurisdiction without the permission of the court. The second type of case is likely to be dealt with by a new amendment to the CPR. So we know it's coming down the pipeline, but it's not quite in force yet. And that's going to deal with your jurisdictional clauses that don't fall within the Hague Convention. So why do we even need two different rules dealing with jurisdiction clauses? And I think the answer to that is that the Hague Convention route is more difficult to challenge if you are a defendant out of the jurisdiction. So under the Hague Convention, you can't run an argument that England is not the proper place and the court ought to decline to exercise its discretion. Whereas with your non-Hague Convention cases, even with the rule change, the court is still going to be making a discretionary judgment call.
Yes, so the Hague Convention exception, if we could call it that, lets you bypass the permission stage, but also considerations of forum non-convenience as well. Whereas the other forthcoming change to the rules dealing with choice of jurisdiction allows you to bypass the permission stage, but not the forum non-convenience stage. So, yeah, as you say, there's still some advantage of being able to bring yourself within the Hague Convention, I would imagine,
Definitely.
for a claimant. So that takes us to the contract gateways. We won't tackle this in huge detail because they're probably pretty well known, but it's within Practice Direction 6B, it's gateways 6, 7, and 8 that are the important ones. Gateway 6 applies to claims in respect of a contract where certain criteria are met. The criteria are that the contract was made in the jurisdiction, or that it was made by or through an agent trading or residing within the jurisdiction, or that it's governed by English law, or previously to the reforms that are about to take place, contains a term to the effect that the court shall have jurisdiction to determine any claim in respect to the contract. So obviously that's going to be amended. In fact, it's going to be removed when the new that amendment that Helen was just discussing comes into force. So these are fairly broad. I mean, in particular, in respect of a contract, does not just apply to claims for breach of contract. It can apply to a claim for total failure of consideration. But nevertheless, you were still operating under a system where there are effectively lists of factual scenarios that need to be complied with if a gateway is going to be satisfied. Interestingly, the contract gateway was, I mean, it's much litigated, but it was much litigated in the case of Brownlee and Four Seasons, both in Brownlee number 1 and in Brownlee number 2. I should say the junior counsel for the claimant in that case. Without going into it in great detail, it's quite a good illustration of how fiercely litigated the very fine details of contractual formation can be, even at the jurisdiction stage. So that's gateway number 6. Gateway number 7 deals with breaches of contract in England and Wales. So again, that's a factual analysis. It's going to have to be consideration of what the place of payment was, or the place of performance, or the place of repudiation. Sometimes obvious, but then on other occasions not. And Gateway 8 applies to claims for a declaration that no contract exists. So then, Helen, you were going to talk about what anchor defendants are.
Yes, because this is a good route for contract claims if you don't fit one of the gateways. So if you can anchor a defendant in the jurisdiction, then you can obtain permission under Gateway 3 to serve out on another defendant, provided they are a necessary and proper party to the claim. And this was a good way, and is a good way, of obtaining jurisdiction over somebody who you otherwise would struggle. You have to have a legitimate legal claim against the anchor defendant, but of course it doesn't matter if the commercial justifications for pursuing them would be absent, but for the need to anchor them in the jurisdiction. So, for example, you'll often get cases where you'll sue an impecunious defendant simply because they are an anchor defendant in order to get your person out of the jurisdiction under the Gateway 3. So it is open to abuse. The courts are aware of that, but it's still a very good tool in practice for contract claims.
Another thing worth mentioning, which I think is it's not strictly a contract provision at all, but it's likely to be very useful in contract cases, is Gateway 4A, which is relatively new. It was only added in 2015. But what that does is if you pass through a gateway with respect to a claim against a party, you can use 4A to bring another claim against them, provided that other claim arises from closely connected facts, essentially. So to give a slightly better, put that in more concrete terms, if, for example, the claimant had claims in contract and tort against a foreign domiciled defendant, and they could pass through the tort gateway, but they might struggle to pass through the contract gateway, despite having a claim in contract, they can use Gateway 4A to bring their contract claim against the defendant. So it's potentially a very powerful tool. It basically means as long as you can bring one of your claims through a gateway, you can bring your other claim against them. And the most sort of obvious example is concurrent liability in contracts and torts, perhaps in a professional services context, but there would be many other contexts for using it. That then takes us to the question of what's a reasonable prospect of success. The criteria. I mean, one would think this would be very straightforward. Courts have been very clear for a very long time that essentially it's the same as summary judgment tests. Okay, so you just have a claim that's more than fanciful, reasonable prospect of success. It's pretty well established and well understood test. Nevertheless, there's a huge amount of case law on this in recent times, and including no fewer than 3 cases going to the Supreme Court on this topic in the last 2 or 3 years. And in the words Vedanta, Parby, and Brownlee number 2, which is the judgment awaited in. Why is it so heavily litigated in this way? I think the obvious answer to that is in big contracts and tort cases, the battle about jurisdiction is absolutely central to the winning and losing of the whole case, and it's not that surprising that parties, particularly defendants, choose to throw everything, if not everything, then a huge amount, at trying to take a point of law or a knockout point or a summary judgment type point at the jurisdiction stage, because to win at that point is obviously an enormous boon for the defendant. May even be decisive.
And isn't that so contrary to all the guidance of the courts, Dan? That these should
it
be
is absolutely
finite,
all the guidance of the courts.
Small.
I mean, our poor Lord Briggs, only twice in the last 2 years, has had occasion to explain at some length that this is not the way it should be done. We shouldn't be having many trials, and that the first instance judge should look at things sensibly in the round. The rule is really designed to weed out cases that are no hopers, not to engender mini trials. And he was very, very clear about that in Vedanta in particular. Nevertheless, it keeps happening. It's understandable in a sense why parties would choose to throw so much at that one question. But really, the bottom line is it's the same test as a summary judgment, and the judge at first instance is to look at things not under a microscope but in the round. So it oughtn't, in theory, to be a difficult test to overcome or to adjudicate upon one way or the other. But there you go. It does give rise to lots of litigation. So moving on to forum non-convenience, which is obviously the third limb of the common law test. I think that the test itself is very extremely well known and well established, so I don't need to explain that in any detail. But I think what's interesting in this context is the fact that now, after Brexit, the courts are going to be required to grapple with it in an EU context, because of course it was effectively after Russo and Jackson and other cases are prohibited under the Brussels regime for the English courts to go there, if you like. And it will be very interesting to see how this is litigated and how parties attack it. I say that because one has all of the normal, perhaps rather humdrum arguments about which is the more appropriate or which is the natural forum for the trial, to do with where the witnesses are and where the experts are and so on, what's the applicable law, where did it happen, all that kind of thing. But also in a lot of forum non-convenience disputes, one has arguments about whether justice can be obtained effectively or at all in the foreign jurisdiction. Matters such as whether the courts there are truly impartial, whether their cost regimes are oppressive, whether people will get a fair hearing, whether there'll be excess delay, and so on. Now, all of these arguments one hears in relation to certain jurisdictions around the world now, they were never allowed to be heard about EU jurisdictions before. Will parties seek to make arguments about particular jurisdictions in the EU to that effect now? I mean, it would have been, obviously, besides being prohibited, I think it would have been almost unthinkable to suggest this before Brexit. But I think now it's not impossible that parties might start to make noises about courts and legal systems in the EU. It'd be interesting to see how the English courts tackle that, whether they give it any credence or not. I don't know what you think about that, Helen, but I mean, I think it would be extremely uncomfortable, for one thing, because although we have left the EU, nevertheless, the UK still has a very close relationship with it, and principles of comity are obviously very important. And I think it'll be very difficult for the courts to be having pressed on the notion that somebody won't get a fair trial in Poland or Italy or whatever country it may be for whatever reason. But I'm quite certain these arguments will start to be made and the courts will have to grapple with them.
Yeah, I think it will be really interesting. I mean, we take the case of Vedanta in the Supreme Court as the example. That was a case where the court accepted Zambia was the proper place under the proper place test, because the dispute was about breach of statutory duty in Zambia. It was Zambian law, Zambian mine, Zambian claimants, Zambian applicable laws applied. But notwithstanding that, the court still found that it was going to exercise jurisdiction under its discretion because of the other factors you mentioned. So the inability of the claimants to get justice in Zambia, in particular, the lack of skilled legal team and the lack of a CFA or legal aid system. But then pop that into the EU context, and you can see that English courts are going to struggle to accept those type of arguments against member states which so recently were considered equal and on a par, and the courts were being discouraged from identifying differences, particularly negative ones.
Well, yes, absolutely. Well, as I say, it would have been unthinkable only a few months ago, but I'm not sure it is now. But I mean, what if there were evidence that a particular system in the EU, there would be, a delay of sort of 5 or 10 years for the case to be fully heard, or the costs were entirely irrecoverable, and the claimant wouldn't be able to fund any litigation there, and so on, or that there might even be evidence about the process itself, because they do take a slightly different approach to things in some civil jurisdictions. All of those things, and they take a different approach to evidence as well. I mean, some jurisdictions are very restrictive rules about evidence that might be considered fair by our standards. All of these things might come into play. Anyway, it'll be interesting to see that develop, because it's not something that we've really had to grapple with before.
But what next, Dan? Is that a full roundup of where we are in 2021, or are we expecting more changes on the jurisdictional front?
Well, I mean, this is a time of great upheaval. I don't think there's ever been. It's like Brexit is like the sort of spade that's been used to sort of turf over sort of everything that we've been working around for a very long time. So to sort of invite further reform seems like you're being a glutton for punishment. But I mean, I think there is likely to be more change. I mean, the thing that everyone's got their eyes on in particular is whether the UK will accede to the Lugano Convention. The Lugano Convention would, if we did accede to it, that just for clarity, that's the convention that, to all intents and purposes, although not identically, reproduces the Brussels regime for the EFTA countries. So the question would be, would we accede to that? And the UK has made its application, in fact, as long ago as April 2020. But the current signatories need to unanimously approve it, and the EU needs to agree it as well. I think my understanding was that there was likely to be an indication from the EU fairly soon on that. But as we're speaking now, there hasn't been one. So we wait and see. I mean, as I say, that in large part, although not entirely, would mean we would be back, as far as the EU was concerned, in a Brussels type regime. So that would be interesting. I mean, there are obviously lots of advantages to that. We have gone sort of full circle very quickly if that happens, but we'll just have to wait and see. For speaking for myself, I've got no real sense about whether the EU is likely to agree to that or whether it will happen or not. I mean, it may be that the EU sees it as part of and the UK as well, as part of a sort of negotiation, just a sort of, a chip in the negotiation. So we'll just have to see what happens.
The earlier I think that could come in anyway would be 3 months from the date of agreement or consent. So I think we'd be talking about midsummer.
Yeah.
Year at the very earliest.
It wouldn't be immediate on any view. So there's that. That's obviously the big potential next change, I suppose. But there are other things. I mean, obviously there's been reform to the gateways. Helen was talking about the reforms which to do with particularly to do with consumer cases, employment cases, choice of court provisions. So those are important, actually. But I mean, the gateways, just broadening out a bit, I mean, the gateways have been constantly under reform. And in 2015, they were amended. That's when Rule 4A, Gateway 4A came in. And amongst other things. And I think it'll be interesting to see how those develop, in the future as well, I suspect. I mean, there's been lots of litigation about the contract gateway, some criticism of it. There's been lots of litigation about the tort gateway as well. So it will be interesting to see whether the gateways stay in the same form that they're in at the moment or not. I mean, of course, there are those who advocate their complete abolition and say we should effectively move to, a much more sort of broad-based, discretionary type of approach, rather than trying to fit cases into particular, boxes. And I suppose that might be one of the things that's considered. But I mean, the effect of leaving the EU and the transition period ending has been a massive upheaval in this area, and I think it's almost certain that there'll be more changes in the future. It's not going to stop here.
No, and definitely some case law in the coming years, I suspect, over these changes and the different use to which the existing gateways can be put. Thank you, Dan.
No, thank you.
And thank you to our audience for watching this far. We hope you have a good rest of 2021.